Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to be hosting this FedSoc forum called The Case for Restore, Injunctions, Patents, and the Future of Innovation. We're very pleased to welcome the Honorable Andrei Iancu, who will be joining us shortly, Professor Adam Mossoff, Dean Kristen Osenga, and Chris Storm as our excellent panelists to this discussion today. And special thanks to Judge Ryan Holte for moderating this discussion. Judge Holte is on the U.S. Court of the Federal Claims and is a Jurist-In-Residence Professor of Law at the University of Akron School of Law. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions, so if you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. And finally, a note that, as always, all expressions of opinion are those of our guest speakers and not the Federalist Society. And with that, Judge Holte, thanks for joining us today, and I'll hand things over to you.
Great. Thank you, Edith. Very happy to be here, and thank you to all of our participants for serving on this panel with me. Brief note that Director Iancu will be joining in a couple minutes late, so we will add him in as he arrives. As Edith noted, we have four panelists, and the topic of discussion is injunctions, patents, and the future of innovation as it relates to the Restore Act. And this is especially interesting to me while serving as a judge and a Jurist-In-Residence Professor of Law. My prior career as an academic resulted in a lot of scholarship work, and I brought out a couple of my law review articles on this, including one on top from a previous Federalist Society panel that Professor Osenga and I did back in 2023 that was published in the Federal Circuit Bar Journal. So there's lots of other reading opportunity for anyone interested as we get things started related to the eBay case and injunctions. The Supreme Court's eBay v. Merck Exchange decision in 2006 significantly limited inventors' ability to seek injunctive relief. The Restore Patent Rights Act, introduced February of 2025, aims to, as the name suggests, restore inventors' ability to seek those injunctions for patent infringement. Currently, 35 U.S.C. Section 283, which is the statute responsible for injunctive relief in patent infringement cases, states the following. Courts have jurisdiction of patent infringement cases may grant injunctions in accordance with the principles of equity to prevent the violation of any right secured by patent on such terms as the court deems reasonable. If the Restore Act were to pass, however, Section 283 would gain a new subsection establishing rebuttable presumption of granting permanent injunctive relief. The language would read as follows. If, in a case under this title, the court enters a final judgment finding infringement of a right secured by patent, the patent owner shall be entitled to a rebuttable presumption that the court should grant a permanent injunction with respect to that infringing conduct. Senator Coons and Senator Cotton introduced the Restore Act in the Senate on 25 February 2025, which was thereafter referred to the Committee on Judiciary. Today, this panel will aim to answer how the Restore Act seeks to rebalance the patent system in favor of property rights. Our panel will include Professor Kristen Osenga of the University of Richmond School of Law, Chris Storm, IP Legal Director at Uber, Professor Adam Mossoff, Professor of Law at Antonin Scalia Law School, and finally, former Director Andrei Iancu, currently a partner at Sullivan and Cromwell and former USPTO Director. We have a variety of interesting questions for the panelists, but we will begin with Professor Kristen Osenga to share 5 to 7 minutes of opening remarks and proceed through the other speakers before we get to those questions. As brief introduction of Professor Kristen Osenga, I will note that she currently serves as Professor of Law and Associate Dean for Academic Affairs at the University of Richmond School of Law, where she teaches and writes about intellectual property law and antitrust. She's also the Chief Policy Counselor at the Inventors Defense Alliance, as well as an active member of the American Intellectual Property Law Association. She began her career in law practicing at the Finnegan Henderson law firm, where she worked on patent prosecution and litigation matters, clerked for Judge Lynn on the Court of Appeals for the Federal Circuit, and after clerking entered academia, first at the Chicago-Kent College of Law and then at the University of Richmond. She has a BS degree in biomedical engineering, as well as an electrical engineering degree and a JD from the University of Illinois College of Law. With that, I'll hand things over to Professor Osenga for 5 to 7 minutes of opening remarks.
There we go. Thank you, Judge Holte, and thank you to the Federalist Society for putting on this webinar. I am excited to talk about injunctions and the Restore Act today. I was honored to testify in favor of the Restore Act last December before the IP subcommittee of the Senate Judiciary Committee, and I am still a very strong proponent of the bill. I have many thoughts, but I've been tasked with setting the stage for this webinar with some background, including the eBay case and how we got to where we are. I am sure most of the audience is very familiar with the eBay case, but I want to provide a quick recap and also highlight a few things that sometimes get overlooked or forgotten. Before eBay, as Judge Holte mentioned, patent owners could reliably expect to obtain a permanent injunction upon a finding of patent infringement. Studies showed that injunctive relief was granted somewhere in the neighborhood of 95% of cases or more before 2006. In the eBay case, the patent owner, Merck Exchange, was an unsuccessful startup that then licensed its patented technology to other companies. Merck Exchange sued eBay for patent infringement. The court found Merck Exchange's patent was not invalid. eBay did infringe. And while the court granted Merck Exchange a substantial damages award, it did not issue a permanent injunction because the court said Merck Exchange doesn't make anything. It only licenses its technology. On appeal, the Federal Circuit affirmed the trial court's validity and infringement findings, but reversed the denial of injunctive relief because the Federal Circuit's stance was, absent a good reason, injunctions should just issue against patent infringement. eBay petitioned for cert at the Supreme Court, seeking to reinstate the denial of injunctive relief. So the Supreme Court took the case. In a very short, unanimous opinion stated that categorical denials of injunctive relief, which is what the district court did, or automatic grants of injunctive relief, which was the Federal Circuit's practice, were both wrong. Instead, the Supreme Court gave us the now familiar 4-factor test: irreparable injury, monetary damages inadequate, balance of the hardships, public interest, and that would have been fine. Well, it may have been fine. There are definitely questions about the origin of the 4-factor test, but the real problem is that the eBay case spawned 2 concurring opinions. And before I get to those, remember, the majority opinion, unanimous majority opinion, states that no categorical grants or denials of injunctive relief should issue. So, the first concurrence, Robert, Scalia, and Ginsburg, says that while automatic grants are not appropriate, from at least the early 19th century, courts granted injunctive relief for patent infringement. And thus, basically said, history suggests that injunctions are the proper remedy for patent infringement. Nobody ever pays attention to that opinion. The second concurrence, on the other hand, Kennedy, Stevens, Souter, and Breyer, is weirdly enough the opinion that is most frequently cited as for what eBay stands for. It is a concurrence. The Kennedy opinion suggests that policy considerations, not history, should drive whether injunctive relief is available, and notes that sometimes injunctive relief shouldn't issue, including cases involving business methods, cases involving patent licensing firms, or patent trolls for the haters, or cases where the patented technology is a small component of a larger product, such as in standardized technology. So these are the 3 boogeymen of modern patent law, as I like to think of it: business methods, patent trolls, and standard essential patents, or SEPs. And oftentimes these 3 concerns overlap, right? Patent licensing firms sometimes assert business method patents, and SEPs are sometimes held by firms that develop and primarily license their technology. And those are the parties that we see getting hurt by the eBay opinion and not being able to obtain injunctive relief. So I will wrap up with just a few thoughts. First, as I mentioned, the boogeymen of the Kennedy concurrence are generally and often seamlessly woven into the 4-factor test of the majority, which leads to a confused understanding of what exactly the eBay opinion says and requires. Second, patent licensing firms are the ones most often negatively affected by the eBay test as it's being applied. And the funny thing is, the majority opinion in eBay actually calls for going in the other direction. Specifically, the majority opinion notes that the district court's categorical denial of injunctive relief in eBay was in tension with Continental Paper Bag, which is a 1908 Supreme Court opinion that specifically rejects the argument that it wouldn't be equitable to grant injunctions if the patent holder wasn't using the patent. which is exactly what the argument is with respect to patent licensing firms. Apparently, the Kennedy concurrence and the many, many cases that have followed have missed that particular line of the majority opinion. And then last, I want to highlight the significance of the eBay case. Recall, before 2006, permanent injunctions were granted in upwards of 95% of cases where patent infringement was found. After eBay, empirical studies generally say the numbers drop somewhere below 75%, and maybe that doesn't feel like a big change. But there are two facts behind that number that I think matter. First, my friend Christina Akron, who is an economics professor, has done a rigorous study, and that 75% number is misleading because it only captures when there's been a request for injunction. It turns out, and I've heard this anecdotally from attorneys, so it was nice for Professor Akron to show it empirically, companies are actually not seeking injunctions at the same rate they were seeking them before, which means that that decrease in the number of injunctions granted doesn't capture the decrease in actually how many injunctions aren't being granted because they aren't being asked for. So the 75% number only reflects companies who seek it. So injunctive relief is actually being granted in very, very fewer cases than we realize, all because of the eBay opinion. And then finally, and second and finally, the lack of reliable injunctive relief has led to what some call efficient infringement. That's a stupid name. I call it predatory infringement. If the worst thing that will happen to you if you infringe someone's patent is you'll have to pay damages because injunctions won't issue, you might as well infringe first and pay later. And that's what some big companies are opting to do. And that's why we need the Restore Act to stop predatory infringement. And with that, I pass it back to Judge Holte.
Thank you, Professor Osenga. Wonderful summary of the volume of stack of legal scholarship I have next to me in less than 7 minutes. We appreciate your history and background regarding eBay and the Continental Paper Bag case, which is often forgotten. And I'm sure we will come back to that for our question and answer period. Moving on for our panelists, second up is Chris Storm, IP Legal Director at Uber, who's speaking with us today in his personal capacity, but he has authored and presented academic articles regarding the historical development of American patent remedies, as well as the intersection of patent remedies with technology commercialization. He is currently the IP Legal Director at Uber, where he leads Uber's IP policy initiatives and Uber's IP strategy for self-driving and other emerging transportation technology. He received his BS in aerospace engineering and MS in technology commercialization from University of Texas at Austin and his JD from the University of Houston Law Center. After law school, he worked as an associate at Baker Botts and then assistant general counsel for IP at Bell Helicopter. In 2016, Chris joined Uber, where he has since held roles in IP and non-IP positions, and today he'll be speaking with us regarding the congressional and legislative history concerning permanent injunctions. With that, Chris, I'll hand things over to you.
Thank you. And thank you for the invitation. It's an honor and a pleasure to be with you all today. It is a great mistake for anyone to think for a moment that the patent law is primarily intended to reward inventors, because it is not. It is intended to develop industry for the benefit of all the people. I want to emphasize that side of it because after all my years in this work, I feel more strongly than ever that in considering this question, too much attention is sometimes paid to the mere matter of the inventor's reward. Of course, you've got to reward him. That is a matter of sound public policy, but you also have to protect the public. It is a very serious matter to keep the balance right in the patent office and the courts between the inventor, who must be protected on one hand, and the public on the other, who must have its rights preserved. It is just as important that the public should not have to pay more than they should as it is that the patentee should receive what he ought to have. Now, before anyone starts accusing me of hating patents or anything like that, you should know that I was just quoting from Frederick Fish's testimony to Congress in 1919. At the time, Fish's peers called him the Dean of the Patent Bar. His representation of inventors like Alexander Graham Bell, Thomas Edison, and the Wright brothers was legendary. He was also a tireless advocate for the patent system, leading the charge to improve working conditions at the Patent Office, to defeat compulsory licensing proposals, and he even was one of the original proposers of a single patent appeals court. Frederick Fish represents patent industry leadership at its best. He didn't just look out for inventors or his own selfish interests as a patent plaintiff's attorney. He didn't hide behind constitutional rhetoric or property analogies or name calling or whatever. Instead, Fish argued why balanced patent laws benefit society. Fish did this because, love it or hate it, the patent clause as written gives us a populist patent system where power is vested solely in Congress, Patents exist to serve the public, and inventors are left exposed to the tyranny of the majority. In fact, the very first Congress gave us a uniquely American patent system built on conservative patent remedies. Unlike the statute of monopolies, which did not provide for financial damages at law and delegated authority over patent remedies to the English courts, the 1790 Act established financial damages as the sole remedy for patent infringement. Congress was so committed to legal damages that it kept equitable relief out of the Patent Act when modifying damages calculations in 1793 and 1800. Congress even deleted bills of equity from draft legislation in 1790 and gave us treble damages in 1793 to discourage repeat infringements without the need for injunctive relief. Now, if you want to understand how American policy on patent injunctions developed after 1790, I highly recommend an article written by Andrew Morris and Craig Nard titled Institutional Choice and Interest Groups in the Development of American Patent Law. That paper examines how the patent bar emerged as a special interest group that used repeat litigation before activist judges in the Northeast to advance patent policy positions and then lobbied Congress to codify those judicial gains. The early patent industry tried using this same playbook on patent injunctions. The Massachusetts Association for the Encouragement of Useful Inventions petitioned Congress to mandate injunctions in all cases where infringement is proven. Congress declined. The next year, Congress considered new legislation stating that patentees were entitled to injunctive relief, but Congress declined again. Instead, Congress gave us the more modest Patent Act of 1819. Now, every textualist listening in should appreciate that the 1819 Act's core and principles of equity limitation must have had meaning at the time, and that meaning cannot be presumed away or deprived of legal effect. Congress included the word may, both to prevent injunctions and to limit when they are available. Judicial discretion recited by the statute, meanwhile, only applied to the terms of the injunction, not to its availability. Finally, the principles of equity standard had nothing to do with federalism or jurisdictional issues, because the 1819 Act addressed jurisdiction in an entirely different clause than the one that limited when courts can award injunctions. Now, we're going to talk about eBay today. We can quibble about eBay all we want, but Justice Thomas's unanimous opinion gave us the most accurate statutory construction of the 1819 Act that has been proposed to date. Roberts and Kennedy also reinforced key aspects of equity practice that would have been known to Congress in 1819, and their concurrences agree with each other far more than they supposedly conflict. And the net effect of all three opinions is to bring patent cases closer to what Congress intended: financial damages as the general rule, and injunctive relief in extraordinary cases. And for years, Congress has repeatedly tried to defend its policy on patent injunctions by rejecting proposals like Restore. It did so in 1860, 1877, 1879, 1894, 1903, 1906, the list goes on. Lawmakers even declined to liberalize access to injunctive relief when the issue came up in committee hearings throughout history. For example, in 1946, Congress took inspiration from a Frederick Fish letter authored in 1929 and decided to amend Section 4921 to eliminate all forms of profit disgorgement, including via reasonable royalty estimation. Although House committee members discussed the fact that injunctions were far from automatic under current law, they decided not to touch the principle of equity limitation when they amended Section 4921. The 1946 Act and the related 1964 Supreme Court decision, RO Manufacturing, are actually still good law today, even though the Federal Circuit doesn't quote either when in reasonable royalty cases. I bring this up because the 1819 Act and the 1946 Act together illustrate how Congress wants remedies tethered to the patent owner's actual injuries. If you want more than nominal damages, you're expected to explain how the defendant's infringement caused you harm, or why you're actually worse off now compared to what your position would have been if the infringement had not occurred. Remember, you cannot have irreparable harm without actual harm, and you can't determine whether damages are adequate to compensate for the injury under Section 284 or inadequate under Section 283 if you don't even know what the injury is. Congress got this one right. The principles of equity and the injury in fact requirement protect inventors from harm without unduly taxing innovators for their success. Restore undermines this balance by directing courts to decide cases based on counterfactual presumptions rather than the actual facts presented by the parties. Although this probably sounds great if you're a patent lawyer, I believe it's bad news for innovators and bad news for the public.
Great. Thank you, Chris. We appreciate your comments, and I suspect that we'll have a lively Q&A afterwards. Next up in the panel to to basically rebut what Chris was mentioning is Professor Adam Mossoff, who is no stranger to injunction discussions. He is a professor of law at the Antonin Scalia Law School at George Mason University, currently serves as well as the chair of the Forum for Intellectual Property and a senior fellow at the Hudson Institute and a visiting intellectual property fellow at the Heritage Foundation. He graduated with honors from the University of Chicago Law School and served as a research assistant to Professor Richard Epstein, receiving a Bradley Governance Fellowship. Following law school, he was a John Olin Fellow in Law and a visiting lecturer at Northwestern University, clerked for the Honorable Jock Sweener of the U.S. Court of Appeals for the Fifth Circuit. He's testified now 7 times before the Senate and the House of Representatives on proposed patent legislation. Professor Mossoff's recent scholarship is focused on patent injunctions, which is perfect for today's panel, and his scholarship also includes the intersection of patents and pharmaceuticals, standard essential patents, copyright of computer code, and much more. And with that, Professor Mossoff.
Thank you, Judge Holt, and it's a real pleasure to be here and enjoyed the presentation so far. So I'm going to be addressing some of the historical issues, which are important, and the history is deeply relevant because, as Kristen described, the eBay opinion is incredibly short, the majority opinion, the unanimous opinion, and its entire justification, justification for the 4-factor test is that this 4-factor test is, and this is the language from the eBay majority opinion, is historically employed. The 4-factor test represents well-established principles that must be satisfied by a patent owner in seeking any litigant in seeking an injunction, and represents a, quote, long tradition, end quote, of equity practice. And I got interested in this because I also teach remedies and I write in remedies scholarship in law, and remedy scholars who don't have a dog in the patent law debates, either legal debates or policy debates, they couldn't care less about patents, frankly, went apoplectic over eBay. Prominent remedy scholars said there's no such thing as a 4-factor test. We've referred to eBay using words like it is a cancer spreading through the legal system and things of this sort. Normally, staid, academic scholars studying history of equity and law, it's pretty strong language. And I got interested in this because I said, well, maybe there was an exception in patent law cases. Maybe there was an exception in the cases being decided by courts in patent law that they were applying a 4-factor test. There were no other 4-factor tests traditionally or historically in other areas of law. And I have been doing a lot of historical scholarship addressing some of the claims made by Chris. These are long-standing claims that have been made in academic scholarship for several decades. And I have been I have had since in previous work had read all of the patent decisions in the early 19th century, late 18th century, written on the statute of monopolies and things of the sort, and showing the evolution of patents in the United States actually as a property rights system and as a private property rights system primarily, as adjudicated through courts and through private law doctrines. So I went and reread all of the patent decisions that I have from the Federal Cases Reporter from 1790 to 1882. It's about 1,500 of them. I'd read them before for my prior historical scholarship, but this time I was reading them for the remedies analysis. This resulted in Senator Chris Kroon's telling me at the last time I testified before the Senate IP subcommittee on this issue that I, quote, need to get out more often. And I responded that, well, this is how you're doing exactly what you should be doing when this is the type of stuff that you enjoy doing. So I reread and I created a database of the time, of how often patent owners requested injunctions and how often they were issued injunctions and when they were in law and when they were in equity and things of this sort. And what you have is a situation where there are 604 total cases where patent owners sued in equity, meaning because equity was a different court system back then. You actually had to have a justification to get to equity. And of these, you had in 443 cases where a patent was found to be valid because the equity court held the entire hearing. So they heard the claims by the defendant that the patent was invalid, and they also heard the arguments by the defendant that they had not infringed. So you had to control for that. So the cases in which the courts found patent to have survived validity challenges and to have infringed, I found that the courts granted injunctions at 91.2%. So 404 cases, courts granted a permanent injunction. And And very rare, actually, did I find the kind of what we now think of as, quote, the classical equitable factors being deployed. And I only found balance of hardship being argued in 32 cases, public interest being acknowledged in 4 cases, unclean hands in 3 cases, estoppel in 3 cases, and laches in 15 cases. So it shows you how significant this that the courts took this attitude towards issuing injunctions. This is all detailed in my forthcoming article in the Harvard Journal of Law and Technology called Injunctions for Patent Infringement. And I also, though, found, so therefore, I found a significant rate of injunctions issuing, but more importantly, how many times did I find a court applying a 4-factor test? 0. In 404 cases, actually in 604 cases where they are assessing injunctions, 0 times that the courts applied a 4-factor test, confirming what remedy scholars have been saying in patent law, that there is no such thing as a 4-factor test. And it also confirms a lot of aspects of what remedy scholars have said more generally, which is true, that the 4-factor test is conceptually incoherent. Irreparable injury and remedy at law is inadequate are the same thing. These were jurisdictional requirements. They were terms of art. They weren't generalized equitable inquiries about whether you were harmed or not. It was related to issues like, is the harm continuing? Is this a unique asset that is not difficult to assess damages for, and things of that sort? These are classic terms of art phrases that we have in the law, especially in equity, and this is what was being deployed. And since patent infringement is inherently a continuing act, it's a commercial act, they're constantly manufacturing, they're constantly selling, then this is why patent owners were permitted actually to obtain injunctions. It's actually, while Chris is correct that injunctions were not provided for in the 1790 and 1793 Patent Acts, it's actually untrue that injunctions didn't issue, because you could still get injunctions through diversity jurisdiction under the general equitable powers granted under Article 3, and patent injunctions did issue because most patent cases were diversity cases. So the 1819 Act is largely just a declaratory act where Congress was actually settling that you could in fact get this right, because actually the concerns underlying the 1790 Act were the fact that were more federalism concerns and concerns about federal courts interfering directly within internal state affairs with respect to internal matters that largely interstate issues didn't address. So more broadly, the reality is that patents were actually recognized, and I actually found a significant more recognition of patents as property rights, recognized in fact as being protected as property rights through private law doctrines like injunctions, damages, and other types of activities through regular courts and through regular court processes. In fact, patent owners were provided the same type of special treatment as property owners in real estate in being able to immediately sue in equity court, not having to go through a legal process first to prove that their that their damages at law was and their remedy at law was irreparable, because it was recognized as being inherent in the nature of the act. And so what you had is exactly what is what you had being deployed by the courts historically, according to the long history and long tradition of equity, as claimed in eBay, is a rebuttable presumption of an injunction upon a finding of continuing infringement of a valid patent right, in the same way that you had a rebuttable presumption of an injunction for continuing infringements of any property rights in any other lawsuit brought or petition brought in equity. Thank you. And I think we would rather have kind of more further discussions about, and I would like to hear from Director Iancu. So I'm going to then yield my time any other time and for further discussion.
Thank you, Adam. And actually, before we move on from the historical notes, I just wanted to go back to Chris, since there was a question that came from the audience. And I think Professor Mossoff addressed this, but Chris, just to clarify on what you mentioned prior to 1819, you're not suggesting that courts did not award injunctions in patent cases, correct?
Correct. The courts awarded injunctions in patent cases. They did not have the authority to do so from Congress. The Judiciary Act was used as an end around of the remedies that Congress set in 1790, but doesn't mean that they were supposed to do that. And if you look at it, it doesn't make sense that Congress would have permitted injunctions, because it doesn't explain why did we get treble damages in 1793? Why did Congress keep not resolve the jurisdictional issue in 1793 after Joseph Barnes called this out in his very influential treatise in 1792. Why did the 1819 Act, why was it written the way it was, right? This is a pattern that was occurring at the time. Scholars have identified this pattern in other areas of law outside of remedies, where judges were looking to English law. They just assumed that the Patent Act as a whole was merely restating what was happening in England and that English courts were the priority, but they weren't looking at the differences between the statute of monopolies and the balance that Congress crafted for Americans. And so when you look at these cases, if they're not citing the statute, if they're not trying to apply what Congress was saying, yes, the numbers work out that way, but it doesn't mean that we should embrace what those activist judges were saying over what Congress decided at the time.
Okay. Yeah, quoting Chief Justice Roberts in his concurrence on eBay, a page of history is worth a volume of logic. I just wanted to clarify from a historical perspective that injunctions were issuing in courts for patent cases, starting with the original Patent Act. And Professor Mossoff, just to clarify your notes, empirically looking at those historical patent cases, injunctions were actually issuing perhaps more often in the early patent cases. Is that correct?
Yeah, I mean, well, I mean, they were issuing, on a finding of infringement of a valid patent in over 91% of cases. And I have to say, and like I said, I've spent a lot of time studying the history. And while there were, yes, judges citing to the statute of monopolies, and they were citing, and there were claims that we were following the statute of monopolies. There was just as much, and if not more so, because there's always minority and majority rule approaches of things. The judges actually pointing out the significant differences between the U.S. and England, and that we were not modeling ourselves after the statute of monopolies. For instance, if we were, we would have, first of all, the statute of monopolies is a limitation on the executive authority. If we were following the English model, then patents would have been put in Article 1, not Article 2, not in Article 1, in the people's representatives, and as a delegated power to the Congress, as a representative of the people to secure their rights. And and also the many other differences, such as the protection of the rights to transfer them and to license and to profit in the marketplace through lots of different traditional mechanisms, which you were actually prohibited from doing because in England, patents were a special privilege grant to you from the Crown personally, and so you weren't allowed to transfer it. It wasn't a property right in that sense, and therefore you had you had to work with other people. Patent owners could immediately transfer their interests, and in those cases, in many of the cases, the courts relied upon and cited to real property cases. In fact, our terms, licenses and assignments that we have in patent law comes from common law real property doctrine. These were the terms for how you commercialized and transferred your interests. I also teach first-year property, and these are the concepts that I teach to my first-year property students. So I appreciate that Chris is identifying the fact that there are some people in history that talk about the issues that he's talking about, which is true. But the reality is that, yes, I mean, as in all things in law, there's contested views, and you have to look at what was actually the dominant doctrine that was applied. And the dominant doctrine that was applied was not what Chris is identifying. And I would point to people in my Who Cares What Thomas Jefferson Thought About Patents article, as well as my injunction function piece, where I actually detail and I talk about the 1819 Act and how it reflects the declaratory act that Congress, the type of declaratory act, not the type of creation of a property interest, but a declaratory act itself, not the creation of a remedial act that you would expect to see from Congress.
Great. Thank you.
I want to now turn it over to Director Iancu.
Absolutely. So yeah, moving from the 18th century on through the 19th, 20th, and into the 21st century, we have Director Andrei Iancu, currently partner at Sullivan and Cromwell, former director of the USPTO. He's a triple UCLA graduate, earning a Bachelor of Science degree in Aerospace Engineering, Master's degree in Mechanical Engineering, and Juris Doctor. After law school, Honorable Director Iancu joined the law firm of Irell and Manella, where he was promoted to partnership and served as the managing partner of the firm for over 6 years. He was confirmed as the director of the PTO 94-0 in February of 2018 and remained there until January of 2021. Today, in addition to being a partner at Sullivan and Cromwell, Andrei serves as the co-founder and senior advisor of the Renewing American Innovation and the Center for Strategic and International Studies. He's also co-founder and chairman of the board for the Council for Innovation Promotion, which is also known as C4IP, a bipartisan coalition led in part by former federal judges and USPTO directors, dedicated to promoting strong and effective intellectual property rights that drive innovation, boost economic competitiveness, and improve lives. With that, we'll hand things over to Andrei.
Great. Thank you, Judge Holt. Great to be with all of you, fabulous panelists and the audience, and to the Federalist Society for putting this on. Don't know if I can compete with the depth of academic thought from Chris and Adam and Kristen, but especially, going back to the 18th century, but we'll do my best, and we'll talk a bit about where things stand now in the administration and Congress. First, to respond to a point about Congress not having legislated on this issue from the beginning of the Patent Act in the end of the 18th century. Again, I'm not an academic, but I'm not sure that congressional action was needed at the time. I mean, the Constitution gives Congress the power in Article 1, Section 8, Clause 8, right, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So it gives Congress that power, and then Congress establishes the Patent Act of 1790 and then 1793. It seems to be inherent in the constitutional grant and then the Patent Act itself that they are exclusive rights. And I don't personally, I've never understood, and this is something I don't understand from some of the more recent court decisions since eBay. I've never quite understood how you can practically enforce an exclusive right with non-exclusive remedies. And you can get, we can get academic, and obviously there are ways to, justify all of this. But at bottom, if you just ask common legislators who are not steeped into these issues, or common folks who are just asked about what is a patent, the first thing that comes to mind is the right to exclude. Just like, what does it mean to have a house? What does it mean to have own land? What does it mean to own property of any kind? The first answer is, I have the right to put a fence around it and keep you out whether I'm in it or not. And I think that's the natural understanding of the words exclusive right in the Constitution itself. And I don't know that you need a positive articulation for Congress, once you've said the exclusive right, that you need more to say, yeah, and by the way, by exclusive right, we mean injunctions and not just money damages. Now, of course, if courts begin to deny injunctions for one reason or another, or there might be, other reasoning behind it, then you probably need legislation. And that's basically where we are today. And obviously, we've heard from Professor Osenga about the eBay case, and then all the history since the eBay case. And the question now comes, does Congress have to come back and legislate to overrule this judicial development in the last 20 years or so, where courts believe that they can enforce exclusive rights with non-exclusive remedies? And indeed, Congress has a bill. It's bipartisan and bicameral. It's called the Restore Patents Act, and was introduced in the last Congress. It's been reintroduced just recently in this Congress, again, in both chambers of Congress, and it's awaiting further action. And it's a simple bill. It's a one-sentence bill that effectively just says that if a patent owner proves that the patent's been infringed, it shall be entitled to a presumption that an injunction should issue from that finding of patent infringement. Doesn't mean it's automatic. It's ultimately still an equitable right. That's always been the case, as Professor Mossoff indicated. But nevertheless, a presumption exists that, hey, it's your property right, somebody's trespassing on it, you have the right presumptively to exclude them unless there are exigent circumstances for one reason or another. So what is the administrative view on this? So far, for many years since the eBay decision, the administration of that's under the leadership of both parties has been rather silent on this issue. But it so happens that in this administration, this administration has taken a position on injunctive relief very recently, just a few weeks ago, not on the Restore Patents Act per se, but in a particular case called Radian v. Samsung Electronics in the Eastern District of Texas, where the plaintiff, Radian, is actually a non-practicing entity, has patents, but is not actually practicing those patents at the moment, and is actually asking for a preliminary injunction, as a matter of fact. And the Department of Justice, in combination with the U.S. Patent and Trademark Office, put in a statement of interest, saying that basically, to summarize a fairly lengthy brief, that injunctive relief, especially at the preliminary stage, but it applies to permanent injunctions as well, are appropriate remedies, even where the plaintiff is a non-practicing entity. Again, the statement of interest accepts that this is an equitable remedy and that it's a balance of factors, but ultimately it recognizes that money damages is most often not sufficient to discharge an exclusive right or to enforce an exclusive right, even if the plaintiff is a non-practicing entity, and of course, even more so, one would presume, if the plaintiff is practicing the patent or a competitor.
Andrei, can you interrupt for 1 second and read from that brief, and maybe you can share some further insights on it? So this is from the Department of Justice's statement of interest in the Radian case in the Eastern District of Texas. The incentive to innovate at the heart of the Patent Act is undermined when the availability of preliminary injunctions to block infringement is unduly limited. Congress has authorized injunctions, quote, in accordance with the principles of equity to prevent the violation of any right secured by patent, and injunctions are vital to the patent system for encouraging innovation. Without the possibility of injunctive relief, the right to exclude granted by the patent would be diminished, and the express purpose of the Constitution and Congress to promote the progress of the useful arts would be seriously undermined.
Yes.
Go ahead. Back to you, Andrei.
Yeah, exactly right. And it has several statements to that effect. And to support those statements, it cites two primary problems with not granting injunctive relief in circumstances of patent infringement. One is that the patent owner, whether it practices or not the patent owner loses control over its property right. And even if the only business of the property of the patent owner is to license that patent, then it still loses control over whom to license, under what circumstances to license, what territory, obviously, what rates in certain circumstances. And as a second factor, it cites that the value and damages in a patent infringement case are very difficult to calculate sometimes. And as a result, money damages are usually difficult to assess, and therefore irreparable harm can be presumed. I do want to touch briefly on what Judge Holte just mentioned about from the statement of interest that injunctions are critical to the incentive to innovate. And I want to address Chris's point that the patent system is not there only to incentivize inventors to innovate. And that is absolutely right. The patent system is meant to be a quid pro quo. It is a balance. It is on the one hand, incentivizing inventors, on the other hand, transferring that knowledge to the public and giving the public access to that knowledge. And therefore, innovation is incentivized, public gets access to it, and others can invent follow-on technologies from there, and it builds on itself. But those issues, it would be a mistake to think that those issues are at odds with each other. The right of the inventor and the incentive to the inventor and the right and benefits to the public are symbiotic benefits of the patent system. Obviously, there are negotiations that always take place. Sometimes there are disagreements and litigation needs to resolve those things. But in the end, at the high level grand scheme, and if you look over the arc of history of the United States from its foundation till now, with the patent system as we know it, it is a mutually beneficial quid pro quo. And what's interesting is that James Madison saw this early on. And in the Federalist 43, the first paragraph of Federalist 43, where he defends the intellectual property clause, he says that the right of useful the public good fully coincides in both cases, patents and copyrights. The public good fully coincides in both cases with the claims of individuals. He recognizes this beneficial quid pro quo. So the practical effect in the end is right now, the status quo right now is that we have an administration that has taken a public position as to the benefit of injunctive relief and the harms that come from the eBay line of decisions of not presuming irreparable harm in the case of patent infringement. They've taken a public position on this. We'll see how the court decides now. And we will see if the administration likewise now supports the Restore Act, which effectively would address the concerns articulated by the statement of interest in the Radiant case. One final point. In the final month or weeks of the first Trump administration, Congress passed and the president signed the Trademark Modernization Act. In the trademark context, that statute includes a sentence that addresses the same issue for trademarks. And in the Trademark Modernization Act, we say, or it says, that that in the case of trademark infringement, there is a presumption of irreparable harm to overcome the eBay concerns if they were to be applicable to trademarks. So Congress passed that legislation. President Trump signed it 5 years ago. Let's see if that gets to be repeated with the Restore Act in a similar context, but on the patent side.
Do you mind? I know we're running out of time, but I think the audience would enjoy a quick update on Radiant because there's some news that came out there. The Radiant did withdraw its request for a preliminary injunction after it learned that Samsung was no longer using the infringing functionality, and which is I'm kind of bummed about it. I really liked that Radian was pushing this, and I like the DOJ's incursion in here. I wanted to see this case play out because, frankly, I think it would show why Restore is bad policy. We have to remember that Restore doesn't help injured inventors as much as it silences them. Remember, it's more than just a one-sentence amendment to Section 283. There's pages of findings that crafted direct courts to do things like assume harm as a given instead of asking patent owners to tell their story. And I don't know about you, but I hate when we silence our own clients on this point. We saw this in the December Restore hearing when Jacob Babcock testified, and I'll quote here, "My experience working with lawyers in this case is that they say we are not even going to request injunctive relief anymore because we can't get it." Those lawyers were wrong to silence their client. Based on Babcock's testimony, New Current had an actual injury in fact story that needed to be told, but apparently their lawyers decided to treat their client like just another unharmed patent holding company. This happens every day. Ecofactor case. My amicus brief that I filed in Ecofactor was the only one to call out the fact that Google actually hurt Ecofactor, and if Ecofactor's counsel had followed the law correctly, they could have asked for more money, right? Nobody seems to care about the actual injury. We're treating patent owners as a monolith as if they're all the same. Some of these, we talked about Continental Paper Bag. There are some non-practicing entities that are like Continental Paper Bag, that are like Margaret Knight, who built a business, acquired a patent, suffered actual injury when their competitors infringed the patent. We should let those stories through. But at the same time, we shouldn't presume that every anonymous patent holding company is Margaret Knight. Instead, if you care about small businesses, if you care about entrepreneurs, if you care about little tech, then you want them to tell their story in court so they can have better access to patent remedies than the typical unharmed patent holding companies that are dominating the litigation landscape today.
Thank you, Chris. Thank you for that follow-up on the Radian case and update. Any of the other panelists want to follow up on Andrei's points related to Radian or the Department of Justice statement of interest that I read as it relates to Restore?
I'd be interested in hearing if there's any questions from the audience, actually.
To say that, yeah, well, sorry. Yeah, so in questions from the audience, I should note that I think we've had a handful of them. They've actually been covered. Professor Mossoff and Andrei covered them pretty well in following up to the comments from Chris and Professor Osenga. But anything else from the panelists, I guess, on Radian before we move on to the next question that I had related to the Restore Act and protecting the rights of inventors through it? No, okay, we'll move on to that second question. Well, I guess I'll read one question from the audience now that relates to the current discussion. This is from an anonymous attendee, and I'll put it out there to the group. But I guess maybe we'll head back to Professor Osenga specifically to respond to this. When patent rights are weaponized, for example, by non-practicing entities that sue not to protect innovation, the core public benefit can get distorted. That said, if they're too hard to get, inventors may lose incentive to innovate. What is the proper balance? Professor Osenga, any comments on that?
Yes, so many, but I'll try to be brief. I really think that the idea of patent rights being weaponized is overstated. I think oftentimes licensing entities are not using patents as a weapon. They're simply asserting a property right that they have either developed themselves and weren't able to manufacture, or they bought from some other entity that wasn't able to manufacture. In any case, they're providing a market and allowing other companies to use that technology by licensing technology. So the first sentence of the anonymous attendee's question just kind of puts my teeth on edge, but that's okay. I don't really see it as weaponizing. So you're right, though. There is a balance. But I do think that the balance is right now being overthrown by the narrative that patents are being weaponized, that there's lots of nuisance litigation. I think that's a very, very small component. I do think the idea that patents being hard to get, and worse than that, hard to enforce once you get them, which is where we're currently at, I think that's a much bigger problem and a disincentive to innovation. So I'll stop there.
Professor Mossoff, any comments on that? Or the other question that I had, how will the Restore Act and the availability of injunctive relief better protect the rights of American innovators?
Yeah, it's a great question. And, you know, um, the fundamental core point to remember here is that, as Director Iancu, I think, very effectively explained, is that injunctions are a key factor of ensuring what sometimes property scholars call control rights over property. Your ability to decide how your property is going to be used, including, this is a very capacious understanding of use. Sometimes use is non-use. Sometimes use is I want to build a moat around my property. Sometimes use is this is an investment. I'm sitting on this for a while for something else, something recognized by Continental Paper Bag. But more importantly and foundationally, injunctions are what economists call a backstop to commercial transactions. You cannot have a commercial negotiation that sets a fair market price in the marketplace. If someone can say, if you say no, I don't have to listen to you, and I can just take your bicycle, and then you can sue me, and we can go through 10 years of court of litigation before you'll get a reasonable royalty for what will be deemed to be my one-day use of your bicycle or your car. Or perhaps you come home and you find someone squatting in your spare bedroom that you never use. And they say, well, you're not using this bedroom. And so Chris would say, call that being not harmed, because you're not using it. You're not using the bedroom in any way, shape, or form. They're not interfering with any actual direct literal physical use of your home. And he would call that not being harmed. And they would say, and you can sue me and I'll pay reasonable rent. When you say, fine, pay me $1 million, they'll say, no, now you're weaponizing your property rights against me. But I'll pay, but we need to go through court for a neutral judge to determine what should be the reasonable rent. You can see how this would destroy the value of your home economically. Try selling your home with now a compulsory squatter, just like a compulsory licensee. And the value and the use of your home to you would be diminished. And this is exactly what was recognized by the courts, historically, running all the way up through until eBay, when you had this kind of conceptually incoherent four-factor test created through remedies doctrine, because these are all terms of art. To say something's irreparable harm means that there's been a finding of continuing infringement, of which then damages do not effectively capture that. You have ongoing harm, which means that if you only award damages, you're not protecting the exclusive control rights to establish market transactions that need to be established. And you have the difficulty of evaluating this because these are unique property interests, which, by the way, which is why injunctions are presumptive remedies for violations of real property for the exact same reason. It's not an automatic per se rule. People sometimes think of it as such, but there's no such thing as an automatic per se rule in equity, but it's a presumptive remedy, which means that once you show continuing ongoing infringement, and then it's a presumptive remedy. You have a wrongdoer and you have then the burden shifts to them to show why they shouldn't issue with classic equitable doctrines like estoppel, laches, and things of that sort. It's not a freestanding, well, you're a bad MPE, you're a bad person in some way, shape, or form, therefore we're not going to enforce this property right against you. That is not the historical role of equity, and that's not what equity means in legal practice, right? And unfortunately, though, because of the incoherence internally of what the eBay four-factor test has meant, it has kind of become this freestanding evaluation by judges as to whether a person should get an injunction or not, which has completely undermined both the property right function of patents as a driver of economic activity and innovation, which benefits, as Director Iancu said, and as Madison recognized, the public as well, just as all property rights benefit the public through that economic activity. And it's resulted in the lack of enforcement of the actual exclusive right. It's unique that it's actually revealing that founders use the term exclusive right. If they were actually implementing the statute of monopolies, they actually had two terms that they could have used from England, which were monopoly or patent in the Constitution. And it's notable they chose neither in protecting patents and copyrights in the Constitution, the very first time the protection of intellectual property has been put in a foundational country's document.
Yeah, thank you, Professor Mossoff. Chris, I'll hand things over to you for a quick response to Professor Mossoff, since I saw you shaking your head during comments.
Yeah.
And then I'll let you close out with a final word, and then I'll go through the rest of the panel for closeout as well, regarding if Restore or another bill similar would likely pass Congress in order to reverse eBay. So, Chris?
Thank you. Yeah, I think I disagree with the characterization of, but let's put aside congressional policy on injunctions and Congress's role. We seem to disagree there. Even if you say that what courts did in the 18th century, 19th century, 20th century, they can legislate from the bench and set American policy on injunctions, I don't think Professor Mossoff has characterized it correctly. Instead, you look through the lens of actual injury. How was the patent owner actually injured? It's not infringement. Infringement occurs in every case. The question is, what are the consequences of that infringement? And just in the interest of time, I did actually, I'm asking you, Professor Mossoff, in your latest paper, why did you end your study starting in 1790? Why did you end it in 1882? Can you explain why the 1882 date was so significant?
Well, I mean, these are supposed to be closing remarks, Chris. I don't
Okay,
I don't
I
want
want
to
to
take us too long.
opportunity.
I actually explain in the paper why I ended in 1882. It happens to be just I just looked at the Federal Cases Reporter, which is just the first report. That's because what I had from my prior historical research. I could
Okay.
continue then further, but I mean, but the point is that I was responding to, I was testing the claim in eBay that this is a long-standing, well-established historical test. And this is an opinion by Justice Thomas. So when he says long-standing historical test, he doesn't mean 1970. He doesn't mean 1960. He means 19th century or 18th century, especially if you're talking inequity, which is because equity is an historical regime. It didn't even, after you have the merger of law and equity in 1936, which results in some of the confusion of the legal concepts that I think have been demonstrated in our conversation, given that you've had the merger of law and equity and people have lost the concept of understanding of what it means to say irreparable harm, which was originally just a jurisdictional requirement, not a substantive requirement about how you got into equity court or not.
Okay,
So,
the reason
anyway, I would just direct people to respond to take a look at my paper. I mentioned and explain what that I'm just decisions there.
I didn't really get that full explanation out of your paper, and the reason why I asked was because it's just coincidental that the Supreme Court decided Route v. Railway Company in 1881. That's the case involving Thomas Sales, the most notorious patent shark of the 19th century. And this was a huge news story at the time. This went before Congress. Congress was debating whether or not to drop the principle of equity standard at that time. Albert Walker, Thomas Sales's nephew, represented him there, and they said no. Like, if you aren't actually injured, you do not get the benefit of equitable relief. That means no injunctions, no profit disgorgement, nothing. The Sales estate only received nominal damages. That's also part of this equity history, right? And there's the prior Greer cases.
Just to put an opinion,
there's
already
other
4 minutes over. How about let's keep it on the 21st century and just
okay. Well, I just have to rebut this notion that like 19th century case law is a monolith and that courts were ignoring the principles of equity, because they were looking at actual injury. And if you look at the case law, you look at Sullivan, you look at Morris, you look at the Justice Greer cases, they turned on actual injury. And I think that matters for whether or not you believe you need to pass legislation to help injured patent owners or uninjured patent owners. I will conclude, I know we talked about like making predictions. I will conclude with, I have no idea whether or not this bill is going to pass.
All right, thank you, Professor. We'll leave it at that. Professor Osenga, final conclusion remarks on 2025 Restore Act.
I am sad, but I think the answer is it's not going to pass. I think there's too much confusion about what it means, as evidenced by many of the discussions we've had here today.
All right, Professor Mossoff, final words, 2025 Restore Act.
I mean, I think we'll probably see some progress made on it, hopefully. I mean, there's always debate and there's always confusion. There's no bill that's enacted that receives very rarely 100%. It speaks highly of Director Iancu that he was confirmed 94-0. Such votes are very rare in today's Congress. So, and so I think hopefully we'll see some movement, even though there will be continued disputes about it, about the bill.
Okay, and Andrei, you get the final words and give us some insight on the bill. Do you think it'll pass?
Well, I think anyone who tries to predict what Congress might do, especially the passage of any piece of legislation, would be foolish and risk reputation. But look, I agree that I think there'll be debates, progress will be made, and a lot of it will turn on what the administration does. Will the Trump administration, in one form or another, express additional support for the bill, now that it has expressed support in concept for when injunctive relief is appropriate? On a final note, the reality is, in my view, having litigated patents for almost 30 years now, when you distort the market of any property right, and you put a cloud over one of the most fundamental attributes of property, which is the right to exclude, the market gets distorted and the legal system gets distorted. And what we see as a result of this over the last 2 decades or so is an increase, not a decrease, but an increase in patent litigation, and an increase in the length and expense of that litigation. And that's true for both sides, on average, both for the patent owners and for the accused infringers. And that has resulted in an inefficient market. And just to leave with a kudos to Professor Osenga, because she is cited on the specific point of the efficiency of infringement in the administration's brief in the Radian case, and that
I think
scholarship.
Professor Osenga and Professor Mossoff are both cited in that brief.
I was going to say, and Professors Mossoff academic papers that have been discussed here for the history and importance of injunctions. But the bottom line is that having an efficient patent system that works in balance for all sides, like any system of laws that protects property rights, needs to be, the laws need to be clear, and the bundle of rights need to be complete. And then both sides benefit, the private market takes over, parties negotiate in good faith, and when those negotiations break down, the court system is there to resolve those disputes under the clear rule of law. And I think we need to return to a point where in the patent system, that is the driving force.
Thank you for those excellent closing remarks, Andrei, and we appreciate everyone's time. I appreciate the handful of questions that we were, I think, able to incorporate from the audience who joined in. I'll hand things over back to Edith in order to close us out or end our teleforum. And thank you to all the participants for an excellent and lively discussion.
Yes, on behalf of the Federalist Society, thank you so much to Director Iancu, Professor Mossoff, Kristen, and Chris for speaking with us today, and to Judge Holte for moderating. We're so grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with other announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.